Hello again, I'm Frankie Griffin with the Real Estate School for Success and wanted to do some review questions trying to prepare for the state exam. And all of these questions that we're going over today are dealing with property ownership. I like to do questions on this chapter or this module just because there's just a lot of stuff and it's a lot of memory items, quite frankly, definitions that you really need to understand dealing with property ownership. So let's take a look at some of these questions and see how we do during the review. Number one, Sarah sells her home and moves to a new city. Before the sale, she removes her grandmother's antique chandelier, which was installed in the dining room. What category does this chandelier fall in? Real property, personal property, fixture, or an appurtenance? And I will tell you, most people would probably say that's a fixture. And if it were still hanging, it would be a fixture. But it says in the question and in the scenario, and this is what you have to pay attention to on the exam. It's all about how they word stuff. It says before the sale, she removed the chandelier. Before the sale, she owned the property. Now, I'll tell you what you could debate, which we're not, but I can see where you could debate. Is before the sale the same as before it's under contract? Because I will tell you that does matter. And I hate questions like this, but this is the kind of stuff you're going to see. But the assumption is when they say before the sale, before the contract as well. Because once it's under contract, now you can't start taking stuff down. But we're going with the assumption when they say before the sale, that meant before there was ever a contract, before anything like that was ever done, she decided to remove the chandelier. So obviously, once she removes the chandelier, because it said it's been removed, so now what category does it fall under? And hopefully you'll agree it's now personal property. Now, when it was attached, it was considered a fixture. But now that it's been removed, obviously one of the tests in trying to determine whether something is a fixture or not was the intent, right? Hopefully you remember there's 4 tests of a fixture. One was the intent. Well, assuming she removed the chandelier before she entered into the contract, or in this case before the sale, then obviously her intentions were for it not to convey. So that's why it's considered personal property. And I'll tell you, it's stuff like this question really annoys me on the state exam. I'm sure it's going to annoy you. But anyway, moving on. Number 2, John replaces the carpet in his rental home with hardwood floors. When he sells the house, the buyer assumes the hardwood floors will stay. John, however, plans to remove them. Now, that's a dumb question as far as I'm concerned, but you may find a lot of questions on the exam are kind of dumb. Who in the world is going to take up their hardwood floors? But anyway, the question is, which test determines if the floors are fixtures? So obviously they've decided the floor is a fixture. So it's not going anywhere, right? If it's a fixture, it's got to stay. The question is, which of the 4 tests of a fixture would apply here? Obviously, we can't say the agreement because the buyer and the seller had different thoughts on whether it was staying or going. So obviously, they never had an agreement. It's not part of the contract. Adaptation really does not apply here. It does if they did take up floors, that wouldn't affect the use. They could put floors down. It hasn't been annexed, apparently. But intent, y'all, I'm going to tell you, intent's always the biggie. What was the intentions of the parties? That's what we got to take a look at. But, yep, the answer is intent. Intent is key to determine whether something's a fixture or not. And, yeah, and that's what they're looking at here. Okay, which test determines that these are a fixture? It was the intent. And let me just further say, because the floors were obviously still there when the buyer, one, saw the house and obviously made an offer on the house. So at that case, obviously the intent was for it to stay. Now, John may not have thought that. Maybe his agent should have done a better job of explaining it to him. But a buyer has every right to make their offer with the intent, this floor is staying. It's part of the house. It's staying. All right. So the best answer here is going to be intent. Number 3, Tom's property borders a river and he wants to build a dock. However, the river is navigable. That's key. And he faces restrictions. What water right does Tom have? Well, is it full ownership of the riverbed, rights up to the river's center line, use of water without ownership, or control over all the water? Well, so we know we got a river, so we're dealing with riparian rights. Again, if you have river that flows through or borders your property, that means you have riparian rights. But when it comes to riparian rights, it's a huge deal. It really matters. Is that river considered navigable or not? Not meaning put a boat to go up and down the river. Here it indicates the river is navigable. Now, if the river is not navigable, a lot of times you might even consider that to be like a stream or something like that. But if it's not considered a navigable waterway, then your property line would actually extend to the center of the stream. So if that were the case, then the answer would be B, rights up to the river center line. But that's not the case with navigable. The navigable river under riparian rights, your property line only goes to the high water mark, meaning you own up to the edge of the water. So the answer here would be C, the use of water, but without ownership, because none of the land you own goes into the water, but you still have rights to the water. You can still use the water. But that's what we're dealing with here. Again, the explanation says riparian rights allow the use, but not full ownership of navigable waters. So if you get a question like this dealing with water rights, pay attention to whether it's navigable or not. Okay? Now, if they just come right out and say it's littoral water rights, and we know we're dealing with a large body of water, typically non-flowing. But anyway, that's what we're dealing with there. Hopefully that one wasn't too bad. Number 4, Lisa's home is landlocked, and she uses a road crossing her neighbor's property to access the main street. What type of easement does Lisa likely have? Now, y'all, that one should be pretty simple there. We have a law in this country that says that if you own land, you cannot be denied access to your land. Y'all, that's by law. So if the only way you can get or have access to the land is to cross over somebody else's property, then we're going to have to create an easement by necessity, because it's necessary. That's the only way the property owner will be able to access the property. So hopefully the right answer is necessity, and it is. It says this ensures access to her landlocked property. Y'all, the key word there is landlocked. You see something landlocked? Necessity. Every time. Y'all, hopefully that one was pretty easy. Number 5, Emily buys a property and discovers that the mineral rights were sold 10 years ago to a mining company. What does this mean for Emily? Well, let's see. She owns all the subsurface rights. Well, that doesn't seem right because it says that was sold 10 years ago, so she does not own subsurface rights. Not anymore, she doesn't. She can extract minerals herself, not if she doesn't own the subsurface rights. C, the mining company can access the land for extraction. That sounds like something they can probably do. But D, she can prevent the mining company from accessing the land. No, I think the answer is going to be C, and it is. Obviously, the subsurface rights were sold, and it sounds like, based on this question, they were sold prior to Emily buying the property. So the assumption is Emily did not know. She was not informed that those subsurface rights had been sold to a mining company prior to her ownership. Now, I'm sure, in fact, I know that's probably pretty common, and it's pretty sad. And now I will just tell you, just for practical, real world purposes, I plead with you, and if you've watched any or many videos that I've put out, you've probably heard this before. There's two things you've got to do before you ever list a property for sale, or if you're representing the buyer, before you ever present or make an offer on a property. Highly recommend you do two things. You need a copy of the deed and a copy of the plat. Okay? Now, some properties don't have a plat. They may have not been surveyed. Sometimes they don't have like a subdivision plat or something. Then if I'm representing the buyer, I'm strongly recommending you need to get a survey done, or maybe we need to require the seller to provide a survey and furnish me with a plat. The plat's got nothing to do with what we're talking about in this question, but the deed does. If somebody had read the deed to the property, they would have known that the subsurface rights are not included with ownership because they've been sold to a mining company. So, you got to get a copy of the deed. If you're the listing agent selling the property, you need to know this, and it needs to be disclosed. If you're representing the buyer, obviously you need to know this to make sure the buyer understands what they're buying. So in this case, Emily bought the property, and apparently all she got was surface rights and more than likely air rights, but she certainly did not get any subsurface rights. So anyway, nothing Emily can do about it at this point other than not be happy with their agent, that's for sure. All right, moving on. Number 6, David builds a fence that unintentionally extends 2 feet into his neighbor's property. What is this situation called? It's pretty cut and dry. Hopefully this is simple for you. Is it an easement? Nah. Is it an encumbrance? I would think so. Actually, no, it's not an encumbrance. No, encroachment. That would be the right answer. A license. I will tell you, and this is kind of the reason I was kind of debating in my mind here. If you got an encroachment, which I believe that's what this is, but let's look. Yep, it's an encroachment. But if you have an encroachment, that could potentially also become an encumbrance. Now, what is an encumbrance? An encumbrance is anything that would render the property unmarketable. And I will tell you, especially if the title company finds out about it and you're trying to get title insurance, that could, they may not, in fact, I'd be shocked if they would agree to extend title insurance on that property. But anyway, that's not what this question is asking. If you build a fence on somebody else or extends on somebody else's property, then you're encroaching on their property. That is an illegal and or unauthorized intrusion onto another's property. But hopefully that one wasn't too bad. Let's see, number 7. Yep, here's where we're getting into areas that a lot of people struggle with, it seems like. But it says Maria and Tom own a property together. Maria owns 60% and Tom owns 40%. What type ownership do they likely have? Well, obviously, the key is they own different amounts. That they do not own equal amounts of interest. There's only one type of ownership that will allow you to do that, to own property, but in unequal amounts with other owners, okay? And that's going to be tenancy in common. Tenants, in fact, this is critical for test purposes. If they state or suggest that the ownership percentages are not equal amongst the owners, then it has to be tenancy in common. If you have joint tenancy by entirety, all that stuff, joint tenancy, you cannot divide up the interest unequally. If you have 3 owners, for example, then you all 3 own the whole property. You cannot divide up the interest separately. So the only way you can divide up interest like this is with tenancy in common. So that, hopefully, if you can just remember that, that will help you a lot between tenancy in common and joint tenancy. Number 8, a legal description states, southwest quarter to northeast quarter of Section 10, Township 5 North, Range 4 East. Which land survey system is being used? Now, I hope that's pretty simple to you. But that would be the government rectangular system or survey. That's what they use. Anytime you see in there where they're talking about sections and townships and stuff like that, that's the government rectangular system, or in this case, survey. I will, just as an added statement here, if you're on the East Coast and you're getting ready to take the state exam, the government rectangular system is probably one, I'm guessing, is probably the most common way to determine legal descriptions in most states. But when it comes to the East Coast, this system is not used in any of the original 13 colonies. Now, I'm in South Carolina. I teach in South Carolina. And obviously, South Carolina is one of the original 13 colonies back in the day. So in South Carolina, we don't use this system, right? We use meets and bounds, lot and block. We do not use government rectangular system, and I'm stating this because they like to ask that question. Which of the following states would not use the government rectangular system, or maybe which one does use it? Well, the thing you need to be looking for, now one of your answers might be that none of the original 13 colonies, and obviously I'd go with that. But potentially they could list one or so of the original 13 colonies. Obviously they're all on the East Coast. So it shouldn't be too hard if you can just remember the 13 original colonies do not use this system. Okay. And then number 9, Eleanor donates land to a hospital with the condition that it must always be used for medical purposes. If not, ownership automatically reverts to her heirs. What type of estate is this? Well, obviously, it's a defeasible fee estate because of the restriction, or in this case, a condition that was put on the conveyance. And the condition is they have to always use it for medical purposes. But if you also recall, with defeasible fee, there are 3 types of defeasible fees. It could be the fee simple absolute as one of your options here. It could be a fee simple determinable. And it could be a fee simple with an executory interest. Or D says leasehold estate. I think we can rule that one out. So it's either A, B, or C. And I will tell you the key here in this question, the last part of it, it says ownership automatically reverts to her heirs. Now, under fee simple determinable, that's where it requires that if the condition or restriction is violated, it automatically reverts back to the owner or the owner's heirs. Okay, a lot of people get mixed up here and think, well, that's only if it comes back to the owner. No, determinable says if it comes straight back to the owner and or the owner's heirs. But let's see what the answer is. It's fee simple determinable. Ownership automatically reverts upon the condition or violation. So that would be the better answer. Let's going back. The fee simple absolute, that's not it. Actually I said it had to be A, B, or C. A we can rule out because, as I said earlier, it's this when you have a restriction or a condition, you're dealing with a defeasible fee. So fee simple absolute. Remember, fee simple absolute is the highest degree of ownership basically recognized in this country. Meaning there are no conditions, there are no restrictions. You own it outright, you can do whatever you want to do with it, right? That's what fee simple absolute is. But fee simple or defeasible fee, in fact, anytime you see or hear the word defeasible, the first thing should come to mind are restrictions. Or if you hear restrictions, you should immediately think defeasible. And again, under defeasible fee, there's three types. The fee simple determinable being one, but C, fee simple with an executory interest, is also one. And I will tell you, a lot of people for this question would have probably chosen fee simple with an executory interest if they didn't go with B. And the reason for it is because, when you have an executory interest, that means that the grantor in this case, who is Eleanor, would have said, if you violate this condition, it would automatically revert to John Doe. That would be an executory interest. Meaning they've named somebody in the estate to receive the property if the restriction or condition is violated. But in this case, it was not some third party. It said it would automatically revert back to her heirs. The grantor / heirs are considered one and the same here. So if the question is, if it comes directly back to Eleanor or the grantor or her heirs, that's fee simple determinable. But if they name some other third party specifically to receive it, that's what the executory interest is. So A and D you can rule out completely because that's got nothing to do with defeasible fee estates. So anyway, hopefully that makes sense to you. If not, review back over it. Y'all got other videos where I'm actually teaching and explaining this stuff. Y'all check that out. Hopefully it'll help you if it's still causing you a problem. All right, number 10. Last question. A foreclosure sale fails because the debt owed exceeds the property's value. So the property is now held by the lender. What is this type of property called? Short sale property, REO property, auction property, or trust property? I hope that's pretty simple for you. But they're asking, what do you call this type of property that's owned and held by the bank or the lender? That's always called an REO property. REO just means real estate owned, and it happens to be owned by the lender. But if they're asking you a question and it indicates the property is owned or held by the lender or the bank, that's considered an REO property. That's what that is. Okay? I hope this helped a little bit. We're obviously going to be doing some more, and I'll have some up hopefully pretty soon, some more review questions to get you ready for that state exam. But y'all, if any of those topics there cause you a problem, y'all go back into your material, look at, read over it, freshen up, come back and watch this video again, see if you learned anything. But in the meantime, everything you do today, make sure you're shining for Jesus.